well-functioning democracy. At page 92, we again,
paragraph 92.
Paragraph 92, we again emphasize that prosecutors serve as gatekeepers of the system. And we present cases in court. This is the role of the prosecutors. We represent the interests of society throughout these proceedings. And a quotation there, and this is important because it is a quotation, but this is actually very important for prosecutors. It's what we do. The role of a prosecutor, which I mentioned in my opening remarks, comes with great responsibility, as prosecutors are vested with the power to charge the accused, to try accused. We must seek justice, do justice, protect the innocent, and charge the guilty. And at page 95, at paragraph 95.
Yeah, just in paragraph 95, you're dealing with the integrity of the system, which is largely
correct.
Dependent on the integrity of the prosecutor. Can you explain what an integrity?
That is correct.
What integrity of a prosecutor entails?
If as prosecutors we do not act with the requisite standards of integrity, it brings the entire system into disrepute. The integrity of a system is not something that can be assessed as if the system sits on its own somewhere. The integrity of a system is dependent on the integrity of the people who work within a system. And so, therefore, the integrity of a system is hugely dependent on the integrity of every single person who works within that system. And I go on to explain in paragraph 95 that the effect of prosecutorial decisions on people, on individuals, which is also what I mentioned in my opening remarks, the decision affects accused persons, their families, victims, witnesses, law enforcement agencies, and the public. I don't think I mentioned this part in my opening remark. The prosecutor possesses the greatest power to take away the freedom of the person, and the discretionary power exercised by the prosecutor in initiation, accusation, and discontinuance of a prosecution gives him, I should say, or her, more control over an individual's liberty and reputation than any other public official. So this is really what the impact of prosecutors' decisions are on people. I think I'll skip over the quotations.
Yeah, leave the quotations and let's get to 99, unless there was something else that you wanted to explain.
No, I just think
Let's go to 99, and I'd like you to look at the first sentence there where you're saying all members of the prosecuting authority, moreover, have a legal and ethical duty to promote truth and to refrain from conduct that impedes truth. What does that entail?
In a prosecutor's role is to ensure justice in our society. And I want to emphasize that in terms of a duty to promote the truth, it is not a prosecutor's function to seek a conviction at all costs. It is a prosecutor's function to help the court to come to a just decision and to seek the truth. And so the duty of truth, as I say in paragraph 99, it actually comes from it derives from a prosecutor's constitutional obligation not to use false evidence or to suppress material evidence favorable to the accused. This duty of truth arises from various ethical structures and instruments that we have referred to earlier in my testimony, that require prosecutors to ensure and to have confidence in the truth of evidence before bringing or maintaining charges. And then I explain, go on to explain further that more than any other party in the criminal justice system, prosecutors, well, I suppose the police investigating officer would be, I should exclude actually. It should be the investigators and prosecutors have superior knowledge of the facts that are used to convict an accused or used during a trial, and therefore they have the unique ability to present these facts to a court. I go on in paragraph 100 to say a prosecutor may impede the truth-finding process in several ways. For example, by misleading and misrepresenting facts, subverting the truth, or by making false statements or presenting false evidence.
Might I interpose, Counsel, with regard to paragraph 95? That sentence before footnote 47. The prosecutor possesses the greatest power to take away the freedom of a person. I think that should immediately be qualified by what you state at 99. The prosecutor also preserves or protects the innocent. Am I right?
That is absolutely correct, Chairperson.
Just as your role, Advocate Mutlamunyadi, just as your role here, your task is to present all the facts favorable to
NPA or not.
The other way around.
Indeed, I agree. You dealt with what is contained in 100. You tie it with 101 because it is indeed the duty of a prosecutor to assist the court to ascertain the truth, not so.
Yes, I agree.
And in 102, paragraph 102, you are saying, where prosecution is used for ulterior purposes, this breaches the principle of legality. Can you expand a little bit about what that entails, the principle of legality?
Yes, certainly. I think firstly, before I go there, is that on the comment made by the chairperson about a prosecutor possessing the greatest power to take away the freedom of a person, as I had mentioned, Chairperson, that is the case, but the function of a prosecutor is to ensure a fair trial and to ensure that justice is actually seen to be done. So it's not a contradiction as such. It's explaining that in as much as we have this power to take away the freedom of a person, it's got to be exercised within the confines of our role of ensuring that truth and justice prevails at the end of the day. Chairperson.
I understand that as a lawyer, but somebody out there who's watching these proceedings will not understand what jurists and lawyers understand.
Sure.
When you put that statement in a public space, as you do, they will think that that is just your task to make sure or to take away that freedom, the enshrined freedom in the Constitution. So as you qualify that in paragraph 99, I just wanted to make sure that that paragraph 95 should be read and understood in line with what you say, correctly so, in paragraph 99.
Understood, Chairperson.
Remember, we are not talking to ourselves here. We are talking to the nation and people who may not necessarily understand the legalese and the complexities of the space in which you operate.
Understood, Chairperson. Thank you. So getting back to, sorry, Counsel, what was the... Yes,
the principle of legality.
Yes, the paragraph.
Paragraph 102 on page 42.
Yes, so if prosecutors have a power that is given to them in terms of the Constitution and in terms of the NPA Act. And in the event that this power is not used for the purposes that it was intended, then it would indeed breach the principle of legality. So it emphasizes the fact that these powers that we have must be used for the purpose that it has been, for the intended purpose as set out in the Constitution and the NPA Act.
Let's now move over to paragraph 103, where you deal with an accused rights in terms of section 35(3), the right to a fair trial, where you say a fundamental purpose of the right to a fair trial, as already decided in one judgment in the Constitutional Court, is to ensure adequately that innocent people are not wrongly convicted because of the adverse effects which a wrong conviction has on the liberty and dignity and possibly other interests of the accused. Now, in practice, such possibilities exist. If any, explain them. Possibilities that innocent people may be sentenced to jail.
So let me say that if a prosecutor acts with ulterior purposes, it's possible that innocent people may be sent to jail. There have been one or two cases where people that have been convicted have later on, years later, perhaps because of new evidence that emerges, it's been found that perhaps they were wrongly convicted. But those are extremely rare instances. I know of less than a handful of those cases. But every single case where an innocent person is convicted is a case too many. It should never happen. And so as prosecutors, we need to ensure that when we do bring cases, it must be done, as I state in paragraph 103, always in an even-handed, open manner, honest manner, always recognizing the right of an accused to a fair trial. As prosecutors, we should hold that right to a fair trial as sacrosanct, whatever it means. But in particular, the rights of the accused must be protected, but equally, and I hasten to add, because it's often in the context of a fair trial, one forgets or perhaps relegates the rights of victims to a fair trial to further down the ladder. And so one needs to recognize the rights of all those, the accused, the victim, to ensure that there is a fair trial. And as prosecutors, we are required to, if we have evidence favorable to an accused, we are required to present it to a court so that we don't have any adverse effects as a result, or the potential of a person wrongly convicted. So these are very, very important principles of a fair trial.
Thank you, Advocate Batohi. We can now move over to paragraph F, or section F of your affidavit, where you deal with the independence of the NPA on page 43, the impartiality of its officials and the implications of these imperatives for the administration of justice. Now, in the majority of these paragraphs dealing with this topic of the independence of the NPA, the prosecutorial independence and the independence of prosecutors permeates almost all the paragraphs contained in this.
Is correct.
Section. Now, let's take 104 and read it with 105. Explain what you refer to as functional independence.
In terms of the Constitution and the NPA Act, the functional independence, which I will explain, and the impartiality of members of the NPA in terms of carrying out their duties are provided for. And the functional independence refers or relates to the NPA's ability to conduct its work without any form of interference, hindrance, obstruction. And so if there's any kind of hindrance, obstruction, etc., that will be impeding on the NPA's functional independence in its ability to perform its functions independently. And the Code of Conduct, well, 105 deals with the UN guidelines on the role of prosecutors, but these are incorporated into the Code of Conduct, which is dealt with, of the NPA, which is dealt with in paragraph 106, which again talks to the independent exercise of the functions and powers in accordance with the prosecution policy directives, and be free from political, public, and judicial interference. Paragraph C of the Code of Conduct further deals with the issue of prosecutors performing their duties without fear, favor, or prejudice, and carrying out their functions impartially. And it sets out various requirements which fleshes out what this impartiality entails. And for present purposes, I will deal with some aspects of that. It provides that, well, item C of the Code of Conduct, C, subparagraph C, provides that prosecutors in acting impartially should take into consideration the public interest as distinct from media or partisan interests and concerns, however vociferously these may be presented. Item C sub F stipulates that prosecutors must act with objectivity and pay due attention to the constitutional right to equality. Item C sub G provides that prosecutors must take into account all relevant circumstances of a case at hand and ensure that